Let's continue our discussion of the workings of the board of directors. First, let's look at board size and composition. So, what's the size of the board? How many directors will you have? And director qualifications. Are the directors required to have certain qualifications? First, the size of the board, that's either fixed in the bylaws or the articles. So you can have a fixed number. So for example, the bylaws or the articles can say the board of directors will consist of 7 members or 7 directors, however you phrase it. You might also in your articles or bylaws put a variable range. The board of directors will consist of 7 to 11 members, right? That's a variable range. And then the bylaw or article provision will say how the number will be fixed. So maybe when you have a variable range, the board will fix the number of directors, or if you have a variable range, the shareholders will fix the number of directors, depending on whatever your bylaw provision says. Usually we have an odd number of directors. Not always, but usually. Why? To prevent deadlock. Right? Usually voting requires a majority, and if you have, for example, 6 directors and 3 vote for, 3 vote against, then you have deadlock and it could be messy. It's better to have an odd number so that someone can win these battles. Director qualifications, the law really doesn't have any qualifications for directors. If you go to other countries might say that the directors have to be shareholders, they might have to be citizens of the country, et cetera, et cetera, et cetera. In the U.S., we generally don't have that. Remember, each state has its own corporate law statute, so there might be one out there that I don't know about, but generally, corporate law statutes do not have any specific requirements for director qualifications. One is that you have to be a natural person, right? In other jurisdictions, you can have a you can have a director that is a corporation. The corporation is a director, and the corporation will designate a natural person to attend the board meetings. It's very strange. At least lawyers in the United States and corporate law professors in the United States consider that to be a little strange. In the United States, we do not have that. In the United States, you have to be a natural person to be elected to the board of directors. Now, your corporation might decide that you want to have certain qualifications for your directors, and if so, you can put those qualifications in the bylaws or the articles of incorporation. Let's talk briefly about the relationship between the board of directors and the executive officers of the company. Remember, the board appoints the executive officers, and the board directs, supervises, and monitors the executive officers. Really, the executive officers are just high-level employees. This is your CEO, general manager, your chief financial officer, your general counsel. These are your executive officers. The board appoints them, the board monitors them. Let's look and see how it's a little bit different, this dynamic between the board and the executives in a closely held corporation and in a public corporation. In a closely held corporation, the shareholders, directors, and executive persons may indeed be the same people. So for example, imagine we have a closely held corporation with 3 shareholders. Well, naturally, each of the 3 shareholders is going to want to be on the board of directors, and naturally, each of these 3 shareholders is most likely going to want a position as one of the executive officers. Why? This is where the power is. The board is the brains of the corporation. The board makes the decisions for the corporation and oversees the day-to-day business of the corporation, but the executive officers are the ones who really run the day-to-day business of the corporation. And so if you are a shareholder in a closely held business, in a closely held corporation, you probably want to be on the board of directors, and you probably also want to be one of the executive officers. Also, the executive officers get a salary, and you want to get that salary too. In a public corporation, the executive officers often have a lot of influence and may even dominate the board of directors. The idea is that the board should supervise, monitor, and dominate the executive officers. But the reality of a public corporation is that the executive officers often dominate the board. And there's a reason for this. Number one, board members in a public corporations are usually part-time. So think, who do you want to be on your board of directors? You want someone with a lot of knowledge, a lot of skill. That person already has another job. They might be the CEO of another public company. How do you get them to sit on your board of directors? Well, they can, and they can help you, but they cannot be full-time. They already have a full-time job. So the directors in public corporations generally already have other positions. And indeed, a lot of directors in public corporations are directors on many different public corporations. And so they can't be full-time employees. They are part-time, and they're not employees, but their job as a director of your public corporation is really a part-time job for them. The board is not as well informed as the executive officers. The executive officers run the day-to-day business of the corporation. They are intimately familiar with every detail of the corporation's working and its competitors and its business. Therefore, when there's some matter that needs to be decided by the board of directors, the board knows that the executive officers are better informed than them, and so therefore they will often defer to the recommendations of the executive officers. Often in public corporations, executive officers are also directors. So the chief financial officer will be an executive officer, but also might be elected to the board. And think about why this would happen. Who do you want to be on the board of directors? Well, you want people on the board of directors who know the business, who know the company, who knows the company better than the executive officers. So the executive officers might also be on the board of directors. Often in public corporations, not always, but often you will see the chief executive officer will be the chairman of the board. Now think of what the job of the chairman is. The job of the chairman of the board is to oversee the board, to be the director of the board of directors, so to speak, and to monitor the executive officers, including the chief executive officer. So now we have the chief executive officer, who is the chairman of the board, who's supposed to monitor him or herself, right? You can see how in a public corporation it's easy for the board of directors to actually be dominated by the executive officers. Let's talk about the doctrine of ultra vires. Sometimes it's pronounced ultra vires. The doctrine of ultra vires is often used by shareholders to ask a court to invalidate action by the board of directors that is not within the corporation's scope of power. In other words, the board has taken some sort of action, the board has made some sort of decision, and the shareholders don't like that decision, and they would like to attack it as outside of the corporation's power. In other words, the corporation did not have the power to do such thing. Now, we've seen what types of powers the corporation has, and those powers are virtually identical with the powers and rights of a natural person. So the question becomes, what type of action might not be within the corporation's power? Now, the first one is if the corporation has a purpose in the Articles of Incorporation. Now, remember when we talked about the formation of a corporation, we said it was possible, but less common, to put a purpose in the corporation's Articles of Incorporation. If the corporation's Articles of Incorporation does indeed have a purpose, and the board's action does not serve that purpose, it might be subject to an ultra vires claim by the shareholders. Secondly, there are certain corporate actions that require the shareholders to approve. So if the law, the Articles of Incorporation, or the bylaws of a corporation require a shareholder vote for a certain action, and the board made the decision and then did not get shareholder approval of that decision, that action by the corporation is ultra vires. It's outside of the corporation's power, and the court can invalidate the action. 100 years ago, it was common to see suits by shareholders when the corporation made a charitable donation. So the idea is that the corporation is a for-profit entity, and everything it does must be to make a profit or with the purpose of making a profit. So if the board of directors approved a donation to a charity, well, it seems like there was no profit motive in that decision. When shareholders use the ultra vires doctrine to attack a charitable donation by a corporation, the board would argue that the donation did indeed serve the corporation's purpose of making a profit by giving the corporation good publicity or creating goodwill for the corporation in the community, thereby increasing the corporation's ability to make profits. Nowadays, the board doesn't have to make such an argument. Most corporate law statutes allow the corporation to make charitable donations without having to argue that it served the profit-making motive of the corporation. Let's talk about board committees. The board can actually set up board committees, which the board committees are just made up of the directors, but it's just a smaller number of directors. We can set up board committees, and the board can even delegate authority to committees. So the board can say, listen, we need to decide this matter. We don't want to get together as an entire board to decide this matter for whatever reason. Maybe we have too many directors. Maybe the directors are spread out all over the country. Let's delegate this matter to a small committee of directors. Let's just say maybe 3 of the directors will form a committee, and they will study this matter, and they will actually decide. They don't need a board vote. They will actually decide. The committee itself will decide this matter. Now, there are some things that committees may not be able to decide without a full board vote, but let's just go with the idea that the board can delegate authority to decide a matter to board committees. Now, there might be ad hoc committees and there might be standing committees. Ad hoc committees are committees that are just formed for a specific purpose or transaction. For example, imagine we have a conflicted transaction. Imagine that our corporation is going to buy a piece of land from one of our directors, or from a piece of land, our corporation is going to buy a piece of land from several of our directors. It's owned jointly by several of our directors. Now we have what we call conflicted transaction. The directors are on both sides of the transaction. What we might do is we might set up a board committee of 3 or 4 of the non-conflicted directors to decide whether the corporation should buy the land from the conflicted directors. We might set up a special litigation committee. Imagine one of our shareholders sues one of our directors for breach of fiduciary duties, or we have a shareholder that sues the entire board for breach of fiduciary duties. We might set up a special committee to decide how we're going to handle this litigation. And we'll talk about that in greater detail later in the course. We might have standing committees. So we might have a board of directors that has an executive committee. So once again, we have an executive committee that will meet more often than the board. We might have a board of directors that meets once a month, but matters come up during the month that needs board attention and even a board vote. So we might set up an executive committee of 3 or 4 directors who will vote on these matters. We might set an audit committee. This is typical in a public corporation, is even required in a public corporation. This is a committee that has financial expertise. So you make a committee, you take the directors who have financial expertise, accounting expertise, auditing expertise, and you put them on the audit committee so that they can work with the auditors to make sure that the corporation is keeping its books properly, and in that way we can protect the shareholder interest. We might have a nominating committee. Each year, certain directors come up for election, certain board seats come up for election, and we need to have nominations so that the shareholders have people to vote for. We might have a nominating committee who will decide who will run for the board seats in the upcoming election. And finally, we might have a compensation committee. Remember, we have to set, as a board of directors, we have to set the compensation for the executive officers. And our executive officers might indeed be sitting on the board of directors. So to make sure that the executive officers that sit on the board of directors don't have undue influence on the decision, their salary decisions, their compensation decisions, we might set up a separate compensation committee that's made up of the non-executive directors, and that compensation committee will then decide the compensation for the executives.